Good afternoon, everybody, and welcome to our webinar on statutory compliance, which we're going to cover all the things you need to know about being fully compliant with health and safety. So first of all, some introductions. Our main presenter today is going to be Dom Greenwood, our Senior Health, Safety and Environmental Manager, and he will be able to give you lots of advice on how we can support you with this. In the background, we've got some technical support. There's myself, the operations manager. I'll be helping to run the polls with you. Victoria is going to be fielding the questions with Dom at the end, and our team is there to field any technical questions or issues that you might have. Hopefully not. The agenda Dom's going to be covering with you today is about statutory compliance, the law and regulations around it, all about what it's meant by a competent person, giving you some examples and what you can do and how we can help you. And we'll give some more information on some additional webinars and training courses that we are running as well. We do want you to ask questions throughout the webinar. We've had to put you all on mute because there's so many people attending today. However, we do encourage you to ask the questions, and to do this, in your chat panel, you should have something like this. If you type in your question and hit send, it will send it through to us, and Victoria will collate them all and then ask them Dom at the end of the webinar. We do want to run some polls similar to how we would at a live event. And therefore, when we're going to run a poll, you will see something like this, a screen like this will pop up. If you, we would recommend that you don't have your screen in full screen mode if you want to participate in the polls, as that doesn't always work, it doesn't always allow you to vote. So I think first of all, we're going to launch or start the process with our first poll. So I'm going to launch this for you now. So do you feel that you have all of the necessary statutory compliance items in place already? So I can see those responses coming through. Just let the last few ones come in. Okay, let me close that poll and share the results with you. So 62% of you feel you do, and 38% of you say you don't. So it'll be interesting to find out, Dom, whether what you say next changes that.
Absolutely.
Okay, thank you. And, I'm now going to hand over to Dom to take you through the webinar. Okay.
Thanks, Sue, and welcome everybody. Thanks for joining today's webinar. So obviously the first the point was on the poll that 62% of you do feel you've got everything in place, with 38% maybe not, and I don't know whether that's because you're not sure of what you need to put in place, and hopefully this presentation will kind of help you with that. And obviously please come back to me if I can help at all and ask any questions throughout, but it's good that 62% of you do. So as we go through, we might cover some of that. So statutory compliance, what actually is it? And there's a couple of definitions, in fact there's probably more than that, but the Health and Safety at Work Act 1974, which is our major piece of UK legislation, places legal duties on employers to protect the employed through the provision of a safe working environment. I think we all know that. I think we all like to think we're doing that at work. Statutory compliance would be the legal requirement that sits around that, and would normally be the responsibility of a nominated person. And in health and safety terms, they often call this person the responsible person, the business owner, chief executive, with then a nominated competent person who would probably then help bring this duty into place. The second phrase there would be statutory compliance is often used to describe what an organisation must do in terms of its legal duties. And I think the word legal is going to be really important throughout this presentation, because unfortunately we don't have a choice. It's not something we can decide to do on a Monday and not do on a Tuesday and then maybe pick up again the following week. These are legally binding. There's various pieces of legislation and regulations in the UK. Some of it's quite wordy, but obviously you can see on the second slide there that both of our UK legislations, which would be the Health and Safety at Work Act 1974 and the Fire Safety Reform Order 2005, require a competent person inside the business. And I'm often asked, what actually is a competent person? And I think on the next slide, I think it reveals what that competent person should be. It should be somebody that's got sufficient training, qualifications, knowledge, and experience. And then it talks about other qualities, and that could be a number of different things, from being in the business for some time, understanding the industry, and things like that. But it allows the person to help the responsible person on health and safety matters. And I think if we just go back to that first phrase, training is really, really important, as we all know. And there's various forms of training. It can be recognised training, it can be on-site training. But having a qualification that sits behind training is really important, that you could then evidence what you've done. Obviously, knowledge in the industry, and I think this presentation is going to be quite general, because I'm very aware of a number of the participants on the call are from very different industries. We've got people from hospitality, from retail to offices to engineering, from factories to warehousing, and obviously different regulations and practices exist in all those different industries. But just think about the competent person in your company. Are they trained? Do they have a qualification? Do they have sufficient knowledge and experience to put health and safety practices in place? The level of competence required will depend on the complexity of the situation and the needs of the organisation. And the last phrase there would just be about proving competence. And should a regulator or an environmental health officer or a fire safety officer turn up, can you evidence what training, experience, knowledge and qualification that this competent person has got? And I think because we're in COVID times, as we all are, the regulators and enforcers are very much trying to be more visual and be around businesses and check what they're doing. I was only in a business a couple of weeks ago, and they'd had a regulatory visit just off the cuff, and they were asked to prove their fire risk assessment, their practices, and what training and qualifications their competent person had. So it is happening. But also it could be elicited after an accident, an incident, an allegation, or in a legal proceeding. If there's a case that goes to court, you may have to prove what training, qualifications, knowledge and experience the competent person has. So I'll just urge everybody to go back and make sure, if they've got a competent person, for one, but secondly, have they done the correct training qualifications, and are they knowledge and experienced? If we can move on. Okay.
Okay, so we have the next poll we're going to launch, which is, do you have a nominated competent person with her health and safety and fire? Just collecting the responses now. I think most of you voted now. Okay, I'm going to close that poll and I'll share the results with you. So there we go, 66% of you have a competent person and 34% don't. So similar to the original poll, wasn't it? With
yeah, very, very similar. And I think they're for the 34% of people that haven't, it's thinking about how you can get one, and there's a number of different ways you can do that. But I think about what you're going to do, really, because again, don't want to labour the point, but should you have an accident, an incident, or a regulatory visit, they will want to speak to this competent person, and we've covered it really. But think about how you can get a competent person, or upskill somebody in the business to be the competent person, because it's not me, it's not coming from me, it is in the regulations and the legislations, and they're both primary pieces of UK legislation. So the next few slides really are going to be what makes up your statutory compliance, and there's probably 12 to 15 different articles or assets that you would need to have for you to be statutory compliant, and also be able to evidence should you have, as we've already said, a visit, an allegation, an incident, an accident, or have to go to court. And the first one of those would be a health and safety policy statement. So the health and safety policy statement sets out how you manage health and safety within your workplace. It demonstrates your business's attitudes towards health and safety, and the steps, arrangements and systems you have in place to ensure you comply with health and safety legislation. It needs to be signed by the highest ranking officer. Over the next few slides, quite a lot of the narrative is directly taken from the HSE website. So it's not from me, even though obviously fully adhere to it, it's from the HSE. So have you got a health and safety policy statement? There are a number of ways you can get one. If you haven't got one, there's a number online. We can also help you with that, but it should be the first thing that staff are aware of so that they can see that you're committed to health and safety. Again, it depends what industry you're in as to how detailed and complex it's going to be. If we think about maybe an office set up in comparison to a chemical plant or an engineering works, they're going to be different, but it needs to reflect what you're going to do on a day-to-day basis with health and safety to keep anybody that enters the building safe. And again, we can help you with that, but that would be the first thing that would make up your statutory compliance. So insurance certificates, there's a number that you can have. The only one that's actually legally binding, believe it or not, is the employer's liability insurance, often referred to as EL. As soon as you become an employer, your policy must cover you for at least 5 million and come from an authorised insurer. That's straight off the HSE website. If we move down slightly, you'll see the 2 exclamation marks. You can be fined £2,500 every day that you're not properly insured, and I'm sure nobody would particularly want that level of fine. So if you haven't got the correct cover, I suggest you go back and have a little look at that. But also you can be fined £1,000 if you don't display your employer liability certificate or refuse to make it available to an inspector when they ask. There's a number of ways you can get this, and there's a number of different companies, brokers and agencies where you can get your employer's liability from. So just make sure you've got your employer's liability in place. Make sure that it hasn't elapsed. Again, through some of the work I've done previously, the amount of companies I've been to where they get an old certificate out and it's either a year out of date or they haven't renewed it or the payments weren't going out properly and they actually find out they're not insured. So just make sure you've got it to hand. You can display it as well in the office or wherever you've got. Obviously, it's best to do that in a compliance folder or statutory compliance folder, but just make sure it's in date. A couple of other insurance certificates that you'll have heard of. It'd be good practice and advised to also have professional indemnity insurance, often referred to as PI insurance, and that would cover legal costs and expenses incurred in your defence. If maybe you've given inadequate advice, instruction, services, if you've lost a client's property, maybe damaged something of theirs, or if there's been an unintentional breach of copyright, loss of goods or designs that could cause your client to lose money. It's not mandatory, it's not statutory, but I thought it'd be interesting and right to put it on the slide as well. And again, public liability insurance that you'll have all heard of covers the cost of any claim made by members of the public who come into your site, building, factory, whatever it might be, and they may have an accident or an incident and they might decide to proceed with liability. And again, that would cover that. Quite oftenly, you might get one certificate from your insurer that would have all of these different products and services in there. You may get 2 or 3 that would cover these individually. But just go back and make sure. It could be that you think you might have PI insurance or public liability and you haven't. So have a conversation with your broker, agent, insurance company, and just make sure you've got the level of cover that you need. Print the certificates out, put them in the compliance folder or on the wall, and then you know you're covered. So that's insurance certificates. Health and safety law poster, probably the easiest one of these to get because they are available on Amazon. There's a number of different places you can get these from. They range from £15 up to about £20. They come in A4, A3, and I think A2 size as well, but it's a legal requirement to display these and fill in the 2 white boxes at the bottom. And the first white box needs to be the in-house health and safety representative, and the second white box needs to be any other health and safety person that you're dealing with. It could be that you've got a consultant like myself. It could be that you're dealing with an external health and safety provider as well. So think about where you're going to put the poster. It needs to be in a staff-facing area. As I say, there is a fine for not putting them up, but it's the easiest one to do. Health and safety management system. So the Management of Health and Safety at Work Regulations 1999 means that you have to have some kind of health and safety management system in place. And there's a number of different ways you can do this. The health and safety policy is the first part of that. We talked about that a couple of slides ago. But there needs to be assessments of risks to employees, contractors, customers and partners and anybody else that's coming into the building, and you'll know those as risk assessments. There's various other names for them, but we're going to cover that later on. There needs to be an element of planning, organisation, control and monitoring. So again, there needs to be a system put in place. So if you have an accident, you can investigate it. Is there a communicational paper trail between staff and management? Do you provide employees with information about the risks? Is there instruction and training for staff on how to deal with risks and being safe in the workplace and maybe using PPE, things like that? Are we putting adequate and appropriate supervision in place? And are we consulting with employees about their risks? So there are digital systems that you can purchase that would do a lot of this for you. However, obviously there is a cost to that. It's just as easy to do it through a paper-based system in a folder with different sections. Again, we can help you with that, but a health and safety management system you have to have. It's part of the health and safety work regs, and you need to be able to show that to maybe an enforcement officer or regulator if they was to come in and say, well, show us your health and safety management system. Do you have day-to-day check sheets, open and close check sheets, equipment registers, maintenance folders, accident logs, incident logs? There's quite a lot of different facets to it. Can you provide that evidence? And obviously, you would need to be able to do that. Fire risk assessment, for instance, fire drills, the whole thing would come under a health and safety management system. The health and safety executives version is called HSG 65, which is quite a long-winded way of looking at a health and safety management system. The newer way is called Plan, Do, Check, Act, and I'm pretty sure some of you have heard of that before. You can use that model for quite a lot of different things, but are you planning what you're doing? Are you checking if it's working? Are you actually doing it? And are you acting on any kind of communication or accidents or incidents or things like that? So Plan, Do, Check, Act would be probably the easier way to do it. Again, more than happy to help anybody with this, but that would be the health and safety management system. We talked about it on the previous slide, but what makes up your statutory compliance? Risk assessments. Some of you may know these as RAMs. Some of you may know these as safe systems of work, but risk assessments is a legal duty to assess the risk to health and safety of staff, employees, and anybody else in employment to which they are exposed while they're at work. And carrying out a risk assessment, it's a valuable way of involving the staff who work there. And again, there's a number of different ways you can do this. There are templated versions online you can get. Don't just download them and put them in a folder and not read them from one year to the next. They need to be specific for what you're doing at your workplace. They need to reflect the activities, the tasks, the people, the building, and any risks that you found. I've seen quite a number of these over the years that are pristine in a folder, never been looked at. The best ones are the ones that are dog-eared and have got coffee stains over them, because it tells me that they're being looked at, reviewed, changed, and staff are actually reading them. Safe systems of work. Employers are legally obliged to provide and to maintain systems of work that are, so far as reasonably practicable, and that's a health and safety term, safe and without risks to health. So with a risk assessment, you would probably have a safe system of work that sits behind any kind of task. So for instance, if you had a cleaning task to do, or a maintenance task to do, there would probably be a safe system of work behind it that a staff member could read and you could train them on, so that you knew they're competent to do it. Certainly in construction and in trades, RAMs are used quite widely. They're not as well known as risk assessments because there's no legal requirement to do them. It's an extra level of control. So according to the Health and Safety Executive, RAMs are not required by law, but they're a good way of detailing the scope of the assessment. So it's a risk assessment method statement. It's similar to a safe system of work, and it's a way of detailing what the risk assessment is asking you to do. Certainly very common in construction. It's not required by the law, but some of you may be used to using RAMs. If you're using RAMs, continue to use them. Just make sure that they're specific for the task and review them. Make sure that they're being read at least annually by the competent person and reviewed to reflect any of the changes in the business or any of the tasks that you're doing. So it's just a quick bit about risk assessments, RAMs, and safe systems of work. COSHH, so the control of substances hazardous to health. I think you've probably heard of that term before. It is a regulation under the control of substances hazardous to health regulations. Assessments are required by law for any substances that are hazardous to health. So I'm sure you are using chemicals that are used for cleaning in processes for a number of different reasons, detergents, acids, alkalis, bleach, whatever it might be. The best thing to do is to look at the back of that container to see if it's got one of the pictograms of maybe a skull and crossbones or a big cross or something like that. If it does have that, you need to do a COSHH assessment. And the easiest way to do that, which is the last paragraph on the slide, would be to download the SDS, which is the safety data sheet. Every product by law has to have a safety data sheet that sits behind it. So if you were to type in, for instance, for an example, Domestos toilet cleaner SDS into Google, you should get a PDF appear, and that is the SDS safety data sheet. If you then download that or print it off, and then take any of the points from that, that will then help you to complete your COSHH risk assessment. Now, depending on what products you're using, certainly in some processes, chemicals, they may need to be more severely assessed than COSHH, and there's a couple of other different ways of assessing higher risk chemicals. So for instance, if there's a chemical that could explode or could do really serious damage, there'd be different ways of assessing those. These are more for general chemicals, but please go back and make sure you've got COSHH assessments in a folder or on your system that reflect what you're doing. If you change the product, you would then need to change the COSHH assessment. So if you move from Domestos bleach, for instance, and then go to a different manufacturer, you would have to do a different COSHH assessment because it's a different product, even though you're using it for the same task. So my general advice on chemicals is if you're using them for a reason and it works, stick with the same manufacturers because it saves you having to do all the paperwork again. But yeah, COSHH is a statutory requirement under the COSHH regulations. And again, should there be an accident or an incident or an allegation or misstorage, the HSE stroke EHO would want to see your COSHH risk assessments and SDS sheets. So that's a little bit on COSHH. So the big one under the fire safety reform order would be the fire risk assessment. And again, you'll have heard of it before. It's a legal requirement if you're responsible for a building, if you're an employer, owner or occupier of a premises, you need to make sure a suitably competent person completes the fire risk assessment. This is a legally binding document that should there be a major fire at your place of work, the fire safety authority would want to see it, and you could be coming into court with you to make sure that you've done everything that it says for you to do. So I think the first question for you to think about is, are you competent to complete a fire risk assessment? And I would suggest that unless you've done a fire risk assessor's course, the answer would be no. For the money that it's going to cost to get a professional in, which would probably range from between £300 and £600, depending on the size of your site and where it is and who you use, I think that's money, really good value for money and money well spent. It's your duty to identify fire risks and hazards in your premises and take appropriate action. In addition, if 5 or more people work at the premises, you need to do a fire risk assessment in a written record. I would suggest that you do one even if you've only got 2 or 3 of you working there, because it's a written record of what you're actually going to do. It will tell you where the fire extinguishers need to go, what fire doors you need to have, how many people are allowed in the building, and everything to do with what would happen if there was a fire happen. So it's a legal requirement. Often businesses don't recover after fire, and effective fire prevention starts with properly understanding the risks. So fire risk assessment, really key piece of statutory compliance under the fire safety reform order. Next slide if we can, please. Thank you. So we're going to talk a little bit about something called thorough inspections / servicing certificates, and these need to be completed and issued by a competent organisation. So you as the maintenance manager, competent person, responsible person, will absolutely need to be doing weekly and monthly checks of all of these things, but a competent organisation needs to issue you a thorough inspection certificate or a servicing certificate on a 6 monthly or annual basis. And the first one there would be fire alarm every 6 months. So the fire alarm should be inspected by a competent agency at least every 6 months, which the government also recommends you following this standard. What does that mean? Well, they're going to come in and they're going to set your fire alarm off. They're going to check it works properly, the sounders, the control panel, everything to do with it, and give you a certificate of thorough inspection, and then probably tell you what needs to be maintained or changed. Again, you need to put that in a fire folder or a statutory compliance folder should you need to be asked to prove you've done it. Emergency lighting, you can quite easily do a daily test, which would be a visual inspection to make sure that it's working properly and the little LEDs are shining. It could also mean that you could do a monthly luminaire test to actually put them on, but annually there needs to be a full 3 to 4 hour drop test where they will actually make sure the emergency lights work and come on properly and last the length of time that they need to. It's a statutory duty under the fire safety order, which again, a competent organisation will come in and give you a certificate. In the same way, so will fire extinguishers. You can make sure daily, weekly, and monthly that they're there, the tags are in place, and the little gauge has got pressure in it. But you need a competent company to come and actually do the pressure tests, refill them, and make sure they're working properly. They must be serviced annually by a competent company, and it's also a legal requirement to keep a permanent record of all servicing, maintenance, and inspections of fire extinguishers. So just a few there on fire. If we can move on. Moving on to something called LOLA, and for companies that are using anything that lifts anything, the regulation will be LOLA, which is lift operations and lifting equipment regulations. So the LOLA regs cover a wide range of equipment, including cranes, forklift trucks, lifts, hoists, mobile elevating work platforms, vehicle inspection platform hoists, and anything really that carries weight. And again, you can see there's a few differences. Some are 12 months, some are 6 months. I've just put some examples in. There's a number of others that you may have in your business. So thorough examinations to be carried out at the intervals specified by LOLA. So forklift trucks is every 12 months, MUPS, which is mobile elevating work platforms, is 6 months. Cranes are 6 months, passenger lifts 6 months, non-passenger lifts are 12 months. So what I would suggest is go back and make sure, one, that you've got a LOLA certificate for anything that lifts anything or carries weight. And if you haven't, get a competent company to do it. But also put all of your assets on maybe an inventory, so that every month beforehand, maybe it pops up to tell you that you need a LOLA inspection on a piece of equipment. And the compliance manager or competent person, maintenance manager, would keep a record of anything that needs to be done. So that's a little bit on LOLA. You may have other things on LOLA that are not on there, so please go back and make sure you've got LOLA certificates. Electricity. So the first thing we're going to talk about is the electrical installation stroke fixed wire test. You may have heard either mentioned. And again, it's very much a misconception that everything's given 5 years, and it's not. I was at a fitness club about a year ago, and I asked to see their electrical installation certificate, and said, "Oh, yeah, we've got 5 years on that." When I got it out, they were only given 1 year, which had already elapsed. So they had to very quickly get an electrical installation fixed wire certificate arranged. Now, the reason for that is it depends how the building was wired in the first place. And it could be that if you're taking over an older building and you're rewiring it and totally stripping everything out, you may be given 5 years. It could be that the installer will only give it 3 years. So please go back and look at your fixed wire electrical installation certificate to see when you need to have another one done. And you can see on the panel there that there's various different things. I know that swimming pools have to be done annually. A bar and place of entertainment has to be done annually, or that part of the facility. So if you think about a leisure centre, the swimming pool area has to be done annually, but the rest of it, maybe the squash courts and the gym and the children's play area, can be done every 3 to 5 years. They sample the pool every year, and it depends what business you're in. It also depends how your building is managed and owned. So if you are leasing it from a landlord, it may be that the landlord takes care of all of this kind of stuff. It may be that they actually say, no, it's your business now in the building, we're going to ask you to do it. So don't get caught out. The very big misconception is pat testing. I was only having the conversation, I think, yesterday. There's currently no strict legal requirement to do pat testing. What the regulations do say is that you need to have done an appropriate and correct test and check of any portable equipment. And the easiest way to do that, or the most effective way to do that, is to do a pat test. Pat testing was developed for the construction industry when the guys were walking around with big kind of converters and inverters and things like that. Most of them have gone battery now, to be honest. But pat testing is the best way to do that, but you're not legally statutory have to do one. However, the best way is to do one for between £1 and £2 per item. But just make sure that if you're not doing pat testing, you can prove that you're doing a visual and physical check and test on an annual basis. Just a little bit on electricity. Emergency procedures. So the law, the Management of Health and Safety Regulations 1999 says that workplaces need to plan for emergencies, and special procedures are needed for emergencies such as serious injuries, explosion, flood, poison, electrocution, fire, terrorism, bomb threats, release of radioactivity and chemical spills, all the really nice stuff that could happen in your workplace. Have you got a plan? Have you got something that you can show staff and that they know what to do? Do you practice it, and does it cover all of that kind of stuff? Or is it just something that's kind of discussed but you don't really practice it and it's not written down? Is it reviewed? So an emergency action plan, EAP is the terminology I'm used to. It could be that you call yours an emergency response plan. There's a number of different ways of detailing it, but the most important thing is, have you got one, and is it in place? Is it trained, and is it reviewed? Because it does come under the Management of Health and Safety Regulations. So that's emergency procedures. Moving on to fire drills and training. So fire drills, essentially in any workplace or public building, they are a legal requirement under the Fire Safety Order 2005, the same order that talks to you about emergency lighting, fire panels, and the fire risk assessment. In the order, it talks about that you should carry out at least one drill per year and record the results. However, good practice is to do it quarterly or whenever a new staff member joins. So just think about what your fire drill regime is. And we all know that it's the most annoying thing, you know, on a wet Monday morning when the health and safety manager starts talking about a fire drill. Nobody really wants to do it, and customers certainly don't want to evacuate. It is not for customers; it's for staff. It's a training exercise for staff. You need to document who's done it, and maybe any points that you need to improve on for the next one. But it's a legal requirement to do at least an annual fire drill. But good practice would suggest it should be on a quarterly basis. So go back and think about how you detail and document your fire drills. Just a quick one on fire drills. Gas, as you'd expect, is statutory compliance under the GSRUR regulations, which is the Gas Safety Installation Use Regs. As an employer, you're legally responsible for the safety of your workers in relation to gas safety. If you don't run gas in your buildings, you don't have to do anything. But if you're running any kind of gas systems, boilers would be the main one that we're going to talk about, but it could be you're running big kind of ovens maybe. It could be that you're running things like that. So an annual gas safety check is statutory compliance, and it has to be by a gas safe engineer. You'll have all heard of the term CORGI. Gas safe has kind of surpassed CORGI, so that is the new competence standard. Gas safe engineer, and they will service the gas equipment, look at the inlet to make sure it's not leaking, everything's working properly, and give you a thorough inspection gas safe certificate. Equally, if you're replacing any gas equipment, having a new boiler maybe, having new cookers, new ovens, whatever that might be, you need a gas installation certificate as well. So just make sure you're looking after your gas on an annual basis, and you've got a gas safe engineer that comes and does your thorough inspection certificate, annual requirement. Asbestos, again, statutory duty, and the control of asbestos regs 2012 applies to all non-domestic premises. But there are a couple of things that you need to be aware of. If your building's built before year 2000, you have to have done it. Any buildings that are post year 2000, you don't, because the use of asbestos was pretty much outlawed in the UK in 1999. So you won't find it in buildings. There's nothing wrong with asbestos if it's looked after properly and it's intact. Asbestos only becomes dangerous when it's disturbed and turns into a dust, and particulates get into the air, you breathe them in, and you then can get lung conditions and worse, unfortunately. So if the building's built before year 2000, if it's non-domestic, if there are public areas in a domestic building, so if you're a landlord and you've got flats or houses in any communal areas, they would have to be looked at, and if there's construction work going on in the building. But certainly public buildings and hospitals and factories, offices and shops would need to have done an asbestos survey. Again, it needs to be a competent organisation that does that. They will also do a risk assessment for you and tell you what you need to do. And it could be that you have to put a asbestos board over the asbestos and it's fully sealed, and that's good enough. It may be that you need to do full removal, which could then incur quite a lot of costs. But asbestos, it needs to be looked at. It is a regulation, and if not dealt with properly, can have serious health issues. As can Legionella, and again, we've all heard of Legionnaire's disease. It's found in water, contaminated water. It's again, the myth would be is that if you drink Legionnaire contaminated water, you'll get it. You won't. Again, it's an airborne bacteria that again gets into your lungs, and there's various different strains of it. The very worst strain unfortunately would prove to be fatal. Again, the duty is under the Health and Safety at Work Act 1974. It extends to risks from Legionella bacteria, and again, a competent agency would need to complete a risk assessment if the water treatment in the building is between 20 and 45. Now, with Legionnaire, the bacteria is generally killed over 50 degrees. So anybody that's got a boiler system that's pushing up water 50, 60, 70 degrees, Legionnaire bacteria would be killed. However, it's more about where the pipes in your building mix. So if you've got a hot pipe run alongside a cold pipe, what could happen is the hot pipe could heat up the cold pipe, and you could then breed Legionnaire bacteria. If you're storing water, you need to do a Legionnaire's check, and then you can read the rest there. So it's definitely appropriate to do one if you've got showers, aerosols, if you've hot tubs in leisure centres, things like that, because they provide a mist when they're being used, and this is where people can then breathe in the contaminated water, and it can then get into people's lungs and that way. It's likely that any of your employees, residents, visitors are more susceptible to infection due to their age or illnesses. So again, a little bit like COVID, if someone's got a weakened immune system and they're exposed to Legionella, they could then pick it up. So just think about what you're running at work: showers, hot tubs, cooling stations, cooling towers, anything like that. You need to have a Legionella assessment completed by a statutory thorough inspection agency. So that's a little bit on Legionnaires for you. PUWER. So the provision and use of work equipment, it's a regulation under the Health and Safety Act. So generally any equipment which is used by an employee at work is covered. For example, hammers, knives, ladders, drilling machines, power presses, circular saws, photocopiers, lifting equipment, and all the stuff that you see on the slides. Not only do you have to service and maintain it, you need to make sure that whoever's using it has been trained and supervised correctly. And I would always get a signed declaration that the person understands how to use the power tool, the pneumatic drill, the oven, the clave, whatever it is you're getting them to use. So again, you can see there are a few differences. So a local exhaust ventilation system would need to be PUWER checked every 14 months, but a power press and press brakes would need to be done every 6 months. And you can see down the list there. When we talk about pressure systems, there's different regulations there, and talks about the pressure systems regulations are normally inspected at 24 months for air pressure plant, hot water boilers every 12 months, refrigeration and air conditioning every 2 years, but you may decide, so every 4 years, but you may decide to do it every year. So you can go better than these, but these are the regulations. Steam pressure vessels 26 months, and then generally power tools would be anything from 6 to 60 months, depending on the equipment. And again, I was with a company yesterday that are going through power tools on an annual basis because they're being used so much. So they're literally throwing all of their drills and things away because they're being so heavily used. So they probably wouldn't need to do PUWER tests on them because the manufacturer's guarantee would cover that first 12-month period. So this is not an exhaustive list. There are loads and loads of different suggestions for different tools and equipment. Just go back and see what you're using in your factories, warehouses, offices, whatever it might be, and make sure you've got the regulatory thorough inspection certificate for that piece of equipment, forklifts, whatever it might be. So that's PUWER, the provision and use of work equipment. First aid. So the employer's legal duties under the First Aid Regulations 1981 require employees to provide adequate and appropriate equipment, facilities and personnel to ensure their employees receive immediate attention if they are injured or taken ill at work. These regulations apply to workplaces, including those with less than 5 employees and to the self-employed. I think there's been a misconception because the qualification is called first aid at work, is that it covers everybody. It's primarily for staff, but again, you would offer that to members of the public, visitors, guests, or members that come in as well. It says on the third line, the regulations do not place a legal duty on employers to make first aid provision for non-employees such as public or children in schools. However, the HSE strongly recommend that non-employees are included in an assessment of first aid needs and to provide them a provision as well. And then in bold, taken from the HSE website, the HSE will prosecute in cases where there is significant risk, a disregard for established standards, or persistent poor compliance with the law. What's that telling me? It's telling me that you should have first aiders in the building whenever you're working, and should a member of the public, guest, visitor get injured, you would also extend the treatment to them as well. Think about AEDs, automated external defibrillators. It's not currently a legal duty to have a defib on site, but for every minute without defibrillation, the person loses 10% chance of survival should they have a cardiac arrest. So I would suggest that if you haven't got one on site, you find out where your closest one is, and if it's more than 60 seconds to 2 minutes away, for the sake of the £600 or £700, I would think about having an AED, because again, the bad press around the fact that you haven't got one if someone was to unfortunately die, I don't think is worth that £600 or £700, and the training so easy. But there's a little bit there on first aid. First aid courses are very cheap, to be honest. The one-day course ranges from £90 to £130 per person, but you could probably get an organisation to come in and train that in for around £500 for the day and get 10 staff qualified. And we'll talk a bit more about that as we go through, but that's a bit on first aid. There's a couple of other statutory compliant duties to consider. DSE assessments, the health and safety DSE equipment regulations would pertain to anybody that's working for more than an hour at a time on a station. The regulations don't apply to workers who use DSE infrequently, but it's a very easy assessment to do. And again, you look at the workstation, their environment, the chair and the desk. Noise at work, the control noise at work regs would again mean that you should do a noise at work assessment should a member of staff be exposed to noise. And again, employees have duties under the regulations too about how they control noise whilst they're at work. Working at height regulations 2005 obviously is to prevent death and injury caused by fall from height. If you're an employer or you control work at height, for example, facility managers, you need to think about maybe have done a working at height risk assessment, but also think about what control measures you're putting in place for that person who could be on a ladder, on a platform. Have they got a harness? Are they wearing PPE, a hard hat, or whatever that might be? Employers and those in control of any work at height activity must make sure the work is properly planned, supervised, and carried out by competent people. And again, we're coming back to that competent person description. This includes using the right type of equipment, as we've already said. So just look at those. Those are the few that I've just briefly put on there for you, because they are statutory duty, DSE, noise at work, and working at height. So I think I'm passing back to Victoria or Sue now.
Yep, it's me. We're going to do our final poll now. So do you feel you need support in managing statutory compliance? So I'm just going to launch that poll now. There we go. Okay, I think everybody's voted. Just close and share the results with you. So we're a similar split again, Dom. We've got
pretty much
67 don't and 33 do. So it's probably those same few people who didn't think they were prepared at the beginning still feel they're not prepared.
Yeah, there's definitely a correlation between over the three polls with the three questions we've asked. And again, with regards to support, there's quite a lot of support online, as you'll appreciate, with the various different pieces of legislation out there. The hse.gov.uk website is really good, and there's a number of different resources you can download on working at height, first aid, electrical installations, gas, Legionnaires, asbestos, and all that kind of stuff. However, there's obviously companies like ourselves, and we're more than happy to talk to anybody that would want some support in statutory compliance. And if we just move on to the last couple of slides. So moving on from that, here's how we can help. We do have a statutory compliance audit that we're happy to send anybody, and you could then do that on your site, and it pretty much covers everything I've gone through today and a number of other things. There's also a COVID section, because whilst we haven't talked about that today, you would argue now that's now legally binding, that you've done a COVID risk assessment, you're COVID secure, staff are made aware of it, so COVID's on there, as well as a number of other things as well. I can come out and do an on-site audit for you and run the statutory compliance audit and give you some recommendations that I think you should put in place at your site. Level 2 health and safety training, level 2 fire safety training. If we talk about the competent person and understanding more about risk assessments and risks, hazards and control measures, those 2 courses would be an absolute minimum standard to go on, and I'm going to talk to you shortly about some course dates we've got coming up. If you're doing any training, just make sure it's recognised, verified and nationally accredited, because there's a number of courses you can do that might seem very good value and may only be sort of 25 to 30 minutes in front of a laptop, but are they going to give you the competence to actually undertake the task? Have they got a badge and are they verified by an awarding body? So just look at those before you sign up. Competent person, again, we've talked about it earlier, but have you got one? If you haven't, how can you get one? But again, a service that we provide is that I will become your competent person and come and visit you on a monthly and quarterly basis. And then risk assessments, we've got a number of templates that we're happy to share to our clients, but also we can create bespoke ones for you. It depends on what you're doing. If you're just an office set up with kind of basic needs, you probably won't need too many. But if you're running a plant, factory, big centre, for instance, then you may need some bespoke ones, and the template ones just won't cut the mustard, unfortunately, because you've got to think that if these are looked at by an enforcing officer or there's an accident, you need to make sure that you've made them really specific to what you're doing. So there's a few ways we can help you going forward. Next webinar we're talking about in about a month's time is going to be, why do we actually manage health and safety? Because surely it's easier not to. You've just been on here for an hour listening to me talk about stuff, and to be honest, I probably could have stayed on here for 2 or 3 hours. There's loads more we could have talked about, but surely it's easier not to. But what would happen if you didn't do it? So that's what we're going to cover next time, the ramifications if you don't do health and safety and control the controllables, and the level of hot water that you could find yourself in. And there should be a training slide as well, which I'm not sure is on there. What's the next slide?
Yeah,
that's coming up, is it? Brilliant.
Yeah.
Okay, so the last slide I think for me is training. As we talked about, there's a number of courses we've decided to run, which would deem somebody competent. The first of which is in a couple of weeks, which is emergency first aid. We're then doing health and safety level 2, fire safety level 2, mental health first aider level 2, and then level 3 safeguarding. And we partnered up with the Kettering Park Hotel, really nice hotel. It's very central, so very easily to get to from anywhere, kind of London, Midlands, wherever it might be. And the course fee includes refreshments all day, lunch, parking, all the books and resources, and the exam and certification fee. And for a one-off course, it's £99 per head. If you want to do 2 or more, or enroll 2 people, it drops to £89. And if you want to do 3 or enroll 3 people, it drops to £79. So it's pretty good value. And after having looked at what our competitors are doing, it represents great value. So, we want to get as many people on these as we can. So if you're interested in booking any of these courses, there is an Eventbrite page, which we can send the link out to, or if you want to contact us directly, we can take your details and get you booked on. But these are really great courses. They're all awarding body verified, nationally recognised, and would stand you in good stead with everything we've talked about today.
So thank you, Dom. That was a really brilliant update, and we've actually had a good number of questions come through. So if you're okay for time, everybody, we'll run through some of the questions that we've got. So Dom, we've had a question that's about the employer's liability insurance, and the question is, with employees working from home, what is the situation on the renewal of EL while all everybody, all staff are working from home?
Well, I would absolutely make sure it's concurrently run. I would always renew it for what it's going to cost. With regards to staff working from home, it brings into question their environment. And this is why a number of companies don't like staff working from home, because they can't really tell what their environment is. You've still got a duty as an employer, you've still got a duty of care over that staff member, even if they're in their home. So have you done a home worker risk assessment? Are you sure they're working in the right environment, whether it be on a computer, lighting, heating, that kind of thing? So don't just think because they're at home, it's now not your responsibility. It absolutely is. So home worker risk assessment. And to answer the question, I absolutely would continue with the insurance. I would go back to your insurance agent, broker, whoever it might be, and tell them the situation, that we've actually got staff working from home, and does it cover them at home? Because I know some do and some don't. It's a little bit like when you're driving a car and you want to drive someone else's on third party, and you think it covers it, but actually it doesn't. So just go back to the insurance broker and just tell them the situation and see if it covers them in their domestic setting.
Okay, that's interesting. Thanks, Dom, for that. We've had another question. Please advise. So it seems like the attendee is a tenant, and the master landlord, it's in regards to risk assessments and fire risk assessments. So does the tenant have to complete it, or does the master landlord need to undertake the risk assessments?
The answer to the question is both. And the reason I say that is the master landlord would probably need to do the risk assessment for the whole building.
Yeah.
But under the fire safety regs, it is up to the individual who's occupying that part of the building to do their own.
Right, okay.
The reason I say that, so for instance, if you had, I work with a couple of gyms, as you know, there's one gym that I'm familiar with that shares the building with Wilkinson's, the shop, and the landlord does it for the whole building, but each business does their own for their part of the building. They're also required to be responsible for emergency process, any fire procedures in their part of the building. Okay,
thank you for that. And another question, our first aiders certificate has lapsed this year, so with COVID, where does the first aider go to renew their certificate?
So they could come and see me for a day, and they could do a course in a socially distanced and COVID secure environment. There's still a number of training providers that are running first aid courses face to face, because my view would be is that yes, you can do learn about the practices online, but you still need to prove competence by doing CPR, the recovery position, choking, stemming bleeding practically. So I think providing the training provider and the venue are practicing safe COVID procedures, I haven't got any issue with doing a first aid course face to face. That's exactly what we're doing in a couple of weeks.
Okay.
However, you can do them online as well, but I just don't think they hold the weight that a face to face course would have. Okay.
And here's an interesting question that so we're getting COVID related queries in terms of you know, our working practices obviously are changing. So first one is, how do you manage fire evacuation tests when we're having to comply with social distancing?
You can still do fire drills. I was at a company 3 weeks ago that did a fire drill, and all they did was do it in stages.
Okay.
So, for instance, they would do, and again, I don't know what business the question has come from, but let's just say you've got an office block, you've got a warehouse and a factory. You would do them individually to prove competence, and you would just do 3 separate fire drills.
Yeah.
Equally, I think we need to remember that a fire drill is a training event. So you can tell staff, we're going to do a fire drill, we need to practice. When you leave the building, you can do it socially distanced. Just remember though, if there was a real fire, you probably wouldn't do it socially distanced. So it's people are going to be running for the exits and trying to get out as quickly as possible. So I think as long as to hit the regulations, as long as you've got some kind of proof that's written down and documented that you've done one, you can do it in whichever way you will, providing it's a safe way to do it.
So I guess it comes back to all of our working practices. We have to review them and adapt them in light of COVID,
absolutely.
don't we? Yeah.
Absolutely,
Okay.
of course we do, yeah.
And I guess a similar question, and that's more about like the first aider side of things. So how does it work with, if employees are working from home, what's the obligation in terms of having first aiders? Because clearly, obviously, people aren't working together in the office. That's one part, and there's a second part to it, is if all employees are working from home, do we still need to have a first aider if we're allowing limited people into the office? Does one of those four have to be a first aider or a fire warden?
I would say yes. I think because I think you've got to think about what would happen should there be a fire incident or an accident and the person on duty wasn't a first aider or a fire warden. Again, I think the HSE would take the view that if you're allowing staff to be in the building and your operation is running, you should be observing the regulations. So my view would be that you still need first aiders and fire marshals in the building.
Yeah.
And I'll go back to what I said earlier about allowing people to work from home, is that you've still got a duty of care over those people. So making sure they've got access to first aid equipment, making sure they've got access to, it's their house. That's where they live. However, the duty of care still belongs to the employer, with a shared responsibility by the employee, I might add. But it's going as far as reasonably practicable, which is health and safety talk, about what the staff member is doing at home. So again, if they've done a home worker risk assessment, a lot of this stuff will be picked up on there. The electrical safety of the property, first aid, have they got a fire extinguisher? And I think then it's up to the employer to actually say, well, actually, you can't work from home because you haven't got these in place, or we're going to provide these for you so that you can work safely from home.
Okay. Okay, brilliant. And then just one final question, although we've got quite a few that's come in, so we're going to have to get back to everybody separately after the webinar, but just one for the purpose of today, and it's around the is the statutory compliance audit downloadable from a website or through contracts with companies?
So, well, the statutory compliance audit is that I was referring to is the one that we've done for our clients, and I don't know if it's on the knowledge base or whether it's something that we're allowing people to use as a gesture of goodwill. There is a number of different ones around, but certainly if you're working with any kind of health and safety consultant stroke advisor, they would have something of that nature. But there are examples online as well that you can use, and some are more detailed than others. But I think contact us directly, and we can decide. We can then have a chat about how we're gonna get that out to people. Yeah.
Okay, brilliant. So it's great to see all these questions coming through, and they're still coming through, so that's great, and we will get back to everybody. Sorry we've not been able to answer them all in this session, but thank you for submitting those. That brings us to an end of today's webinar. So thank you very much, Dom, for that really informative session. It was fascinating, and actually it's thought-provoking as well. And it's really good to hear, what is statutory and what's best practice, because sometimes that can get a little bit confusing. So that's really, really helpful. So for everybody, if you do have any further questions, then please do get in touch via the details that we've got on the slide here. We're always very open to answering any further questions. As I said, we will get back to those that have come through during today's webinar. And as always, we do like to have your feedback on these webinars, because it helps us to with our new webinars that we present moving forward. So I understand, Dom, that we'll be sending a short survey out to capture people's feedback, so we'd really appreciate it if you could take the time and complete the survey, because that really does help us with our the service that we offer to you on health and safety, as well as all our other webinars.
Great.
And then to also just remind people that we obviously have a newsletter that you can sign up to. So if you'd like to stay in the loop and be amongst the first to be invited to our webinars, and to also receive our latest news. As you know, it's always changing at the moment, whether that's COVID, Brexit. So please do sign up to our regular newsletter, and the details are on the screen here. And a copy of the slides will be sent out to everybody, so you will have the slides for further information after today's event. So really that just brings me and Dom to conclude and just say thank you everybody for taking part and listening to our webinar, and thank you Dom for hosting today's very interesting subject. So with that, we'll bring the webinar to a close, and we hope to see you on our future webinars. Thank you everybody.